If you're going through a divorce, you might be wondering how luxury properties will be divided. If you have a luxury home and you want to stay in your home, then you'll have to buy your spouse out of the house if you want to stay in it. And typically, this can be done by agreement. Usually it involves an appraisal of your luxury home to determine the fair market value if you can't reach agreements. But usually that appraisal is necessary even to reach agreements. And if you're able to buy out your spouse and you're able to refinance the loan in your own name, then that's the way you can keep the house. If you want to sell the house and your spouse won't agree, then we might need to get the court involved in order to, seek the sale of the home. And it's not, we can do that. It's okay. And if the other side can't afford to buy you out, then it will be sold. And then the proceeds will be divided based on your respective community property interests. If you have rental properties where you're receiving rental income, if those rental properties are community property rental properties, then that rental income should be considered community property income and should be split between you. It's usually a 50-50 split while you're going through the divorce process. Once you're divorced, if you have any kind of spousal support or child support obligation, then that rental income, if you're receiving it as your separate property income, then that will be included in order to determine what your spousal support or child support obligation will be. So that's kind of treated like income if it's separate property. Rental properties are the same as the luxury home. If you want to keep the rental properties, then if there's a community property component of it, then you're going to have to buy your ex out of those rental properties. Kind of more funkier things can come up with high-end properties with some of our clients where maybe their parents have contributed a substantial amount in order to help our clients buy these properties or maintain these properties, or maybe you bought this home for your parents to live in that's near your house. Maybe your parents gave you money for this property and it's just in your name alone. But your spouse now is saying he or she is entitled to a piece of the property. These issues can get super convoluted, especially when you have family members involved, either loaning your money or gifting your money, or their names are on the title. And so it's really important that you meet with us and we go over all the nuances of your situation to determine how to characterize these assets and whether you have any family members with the right to reimbursement. Whether these assets are actually in your family members' names and not yours. So that's a great way of kind of protecting them and you from your spouse. There's a lot of crazy claims that your spouse can make related to the title to these homes if your spouse isn't on the title to these homes. And so that's something to consider. I know you might think if you're married and your spouse signed a quitclaim deed that he or she certainly shouldn't be entitled to any community property interest in, maybe your luxury home or rental properties or something like that. But unfortunately, in California, there is a possibility that your spouse might still be entitled to an interest in these real estate assets, even if his or her name is not on title, if she or he can show that there was undue influence somehow involved in you having your spouse sign a quitclaim deed. So it's not necessarily so cut and dry as you might think. It's more nuanced. And you might think just because your spouse's name isn't on the title to these deeds that, it's a no-brainer and no, she or he doesn't get any interest in these properties. But I would strongly suggest you consult with a family law attorney, because what we wouldn't want you to do is to sabotage your case and for you to have unrealistic expectations and, draw a line in the sand and say no, and then have to pay a bunch of legal fees, in order to try to go after some argument that doesn't really hold weight in court. We'd want to really carefully vet whatever it is that you think you are entitled to. We want to really carefully review whatever deeds you have related to the property and the chain of circumstances that occurred in order to make sure that your rights are secured and that your spouse doesn't have any claims of undue influence or something like that related to the signing of the quitclaim deed. I know this might sound really nuanced and stuff, but this stuff comes up all the time with these kind of luxury properties or rental properties. So it's something we're super keenly aware of, is making sure that the title, if it's in your name or your parents' names or your brother's name or your sister's name, making sure that's super legitimate so that it's not something that potentially could be, transmuted, or it's something that could potentially the court could find isn't how it's going to play out in court. So if you have, complicated, kind of high asset or real estate or luxury real estate rental properties, come see us and meet with one of our family law attorneys who are very experienced in helping navigate negotiating deals related to determining you and your spouse's separate and community property interests and how these assets are to be allocated to make sure that you're really being protected and you have a strong litigator on your side that really takes into consideration all of these nuances of California law and how it relates to real property and title, to make sure not just that you're protected, but also your parents' interests are protected and any other family members that may be involved. And if we need to hire an attorney that does real property litigation because it involves your parents and other third parties that are outside you and your spouse, that's fine. We have lots of experience involving additional counsel, but it might not be necessary if we can negotiate a deal. That's always our goal, is to negotiate a deal to keep you outside of court, because we don't want your dad or your mom to be deposed. We don't want this to get too messy, right? We want to keep this above board and just negotiate a deal so you can each move on with your lives and with the assets that you need to start with your financial future. If you have a vacation home or a timeshare and you're wondering how it's going to be characterized or divided by a California court, I want you to know that, the court values and characterizes vacation homes and timeshares. I don't want to say all the time, because timeshare is not really a court issue very often, but it has done it before. But more likely than not, we probably don't have to go to court. These issues are usually resolved by agreement in a negotiated settlement. If you think a super high conflict situation that you're not going to be able to resolve because you've tried on your own with your spouse and you're getting nowhere, I still strongly believe we'll be able to help you out with it and be able to settle it, especially if your spouse has an experienced family law attorney as counsel. We can negotiate a deal through a private mediator, through a private judge, or even through the mandatory settlement conference that the court has. The court has a status conference and mandatory settlement conference in every family law case that forces you and your spouse to come to the table. And if there's an appraisal needed of your vacation home in order to determine what it's worth, in order to characterize what's the separate property and community property component, if we need help to determine what your parents' interest is or a family member interest, if they've also contributed to this vacation property, or if you have friends that are involved, fine. I think the real issue is to figure out the data, know the numbers. Once we know the numbers, we can figure out what your interest is. And once we have a value, we can bring that forward and negotiate a settlement. It's usually not worth it to litigate. We usually want to settle this outside of court so you can all move on with your lives. With timeshares, honestly, it's usually worth a lot less than you think. But we'll look and see what the fair market value is. Typically, while getting divorced, nobody wants to keep the timeshare. But if one of you is going to keep it, if you really want to keep it, then you're going to need to buy your spouse out of the timeshare. If your spouse really wants to keep it, then she or he will need to buy you out. But if you're thinking you're going to make a lot of money off of this timeshare, it's probably not going to be a big winner for you. But it is something that typically is divided as part of the divorce process, and we can definitely help you out with that. So if you have questions related to how your vacation home or your timeshare is going to be characterized or divided as part of your divorce, please schedule a consult with one of the experienced attorneys at my office, and we'd love to help you out with that.